Okay. All right. So thank you everyone for joining us, either this morning, evening, or afternoon, depending on where you're joining from. I'd like to welcome you all on behalf of the Australia OPCAT Network to this special presentation on the Australian Human Rights Commission's final paper into implementing the OPCAT in Australia. As many of you are aware, the Commission released the paper on the 29th of June, and it is the culmination of many years' work and encompasses the views of civil society, stretching over 100 organisations and individuals. I think it was 122 submissions over two separate submission rounds and several roundtables all around Australia. So it's a massive piece of work that the Commission has produced, and Edward Santo, the Human Rights Commissioner, has been at the lead, the head of that work for the duration it has been with the Commission. So before I begin, I'd like to first of all acknowledge the traditional people of the lands on which we meet today, the various Aboriginal and Torres Strait Islander people all across Australia from wherever we are joining, and I also acknowledge that we may have other countries represented here and other Indigenous people, and I extend my acknowledgement to them as well, to elders past and present. Just a couple of Zoom etiquette items. So if you could please keep your microphone on mute for the duration of the call, unless you're asking a question. And we will have ample time for question and answer, which will be about 30 minutes of time towards the end of the presentation. And if you do have a question, I just would like to ask if you could use the chat function just to let me know you have a question, and I will moderate the questions. So anyways, without further ado, I'd like to hand over the presentation to Edward Santo, the Australian Human Rights Commissioner. Thank you, Ed.
Thanks very much, Stephen, for that really warm introduction. It's a great pleasure to be joining all of you. I'd echo Stephen's acknowledgement of country. One way or another, we're spread out, not just across Australia, but around the world. But for those of us here in Australia, we're all on Aboriginal or Torres Strait Islander land. In my own case, I'm on the land of the Gadigal people of the Eora Nation. I pay tribute to their elders, past, present, and emerging. It's easy, you know, when you give a fair few speeches to just kind of run over that acknowledgement of country without thinking about it. But particularly when I think about our work on the optional protocol to the Convention Against Torture, I do think quite deeply about the fact that we're acknowledging Indigenous people. We know in Australia that Aboriginal and Torres Strait Islander people are imprisoned in multiple forms of detention at far greater rates than pretty much any other group in our population. It's a source of terrible shame. And as I said in the foreword to the OPCAT final paper, we need to reflect on that. And we need to do two things. We need to acknowledge that this is a problem, and I think we are getting better as a country at acknowledging that it's a problem. And then we need to take strong, positive, constructive steps to do something about it. And I think, to create a bit of a bridge, that OPCAT is still a really important generation-defining opportunity for us to do something about it. Because I think what OPCAT offers is a sign of practical intent to make sure that people in detention are properly protected, that their human rights are respected and upheld. And I think it's also a sign that it's not just intent, but that we are willing to roll up our sleeves and do something about it. So this piece of work that Stephen referred to has indeed been a long time coming. The Human Rights Commission has been involved in work on OPCAT basically since OPCAT came into existence in one way or another, so it's since well before my time at the Commission. My own work over the last few years has benefited very much from the work of others most recently on this project, I've been very, very fortunate to have a number of close colleagues. Sophie Farthing, who many of you will have met, was the principal author along with me of all of the consultation documents. Lauren Perry, who a number of you will have communicated with as well, was very involved, particularly in the most recent roundtables and the final paper itself. And then previous commissioners, Megan Mitchell, the former Children's Commissioner, did a major piece of work back in 2016. Darren Dick, former Aboriginal and Torres Strait Islander Social Justice Commissioners, have all been very interested in this work. And it's been a long time coming for us as a country. So Australia was a fairly early signatory to the Convention Against Torture, and we nevertheless have for too long kind of wrung our hands at best when we are forced to pay attention to human rights violations that occur in places of detention. And I think now is a chance to move forward positively. I'm really hopeful that we will do just that, but we must take that opportunity. That's the thing about opportunities. You can't be passive. You can't just congratulate yourself that an opportunity has come along. You've got to grasp it. I'm particularly well, it's with a mixture of pleasure and a bit of trepidation that I see all of the knowledgeable faces on this Zoom call. Fortunately, my screen is small enough that I can't see you all in one big hit. But I do just want to say how exciting it is for me to see so many of the great and good of the OPCAT world all in one place. One way or another, you've all played a critical role in the progress we've made to date. And I pay tribute to you. It's not work that is glamorous, but it is deeply important human rights work. And I thank you for it. You should feel really proud. I also note that one of our cousins, in a metaphorical term, from the Ombudsman's office, Min Lavelle, is on the call as well. The Commonwealth Ombudsman's office, in a sense, has received the baton on OPCAT now, and is the NPM Coordinator, is the federal NPM as well, and will be, I guess, the organisation in Australia that will be most responsible for taking this stuff forward, as well as federal, state and territory governments and state and territory NPMs. But I'm particularly happy that the Commonwealth Ombudsman and his colleagues take this so seriously, and have approached this with such good human rights intent. So that's the context that much of our work has been undertaken in. In a minute or so, I'm going to do the slightly disconcerting thing of switching to some PowerPoint slides, but they'll be fairly brief, and then you'll see me again. But I guess the other piece of context that occurred right at the kind of end of our process was, of course, COVID-19, and it seems that what we had originally hoped might be a swift but deeply troubling and painful phenomenon is going to be with us in some form for a long time. No doubt we'll come to this when we do questions and comments a little bit later, but we know that people in all forms of detention are particularly vulnerable to contracting COVID-19. We also know that people in detention often have comorbidities that may make them more likely to suffer the worst effects of COVID-19. And so if there were any added impetus that was necessary for us to take this seriously, surely it is that. And so I acknowledge that is that's happening right now. So what I'm going to do in the next sort of 15 minutes or so is walk you through some of our process and I guess some of the outcomes of our work on OPCAT, and I'm hoping that will leave plenty of time for questions and discussion. I just want to double check. Maybe Stephen, you can tell me whether you can see my PowerPoint slides now in presentation mode.
I can see them, but I don't know if they're not in presentations mode.
Okay. They are for me. I might just start talking and see whether that changes anytime soon. Maybe you can let me know, Stephen, if in the next minute or so it's still not in presentation mode. Otherwise, all my big reveals, which are not really big reveals at all, will be lost. So what you should have in front of you is a picture of the front cover of the report. I'm hoping that a number of you have cracked that front cover already and have had a look through it. I'm not going to kind of run through and give everyone chapter and verse of the paper itself, because it's pretty brief, mercifully brief by Human Rights Commission standards, and I'm confident you'll be able to read through it. So a couple of observations about the consultation process itself. It formally kicked off back in February 2017, when the federal government, through the Attorney General, the then Attorney General, announced that Australia intended to ratify OPCAT. At the same announcement, George Brandis asked me on behalf of the Human Rights Commission to conduct a two-stage consultation process, particularly focused on civil society, to get to the bottom of how best to implement OPCAT here in Australia. And so we've tried to do that as rigorously as we possibly can. And again, I pay tribute to so many of you who have played such an active role in that process, in enabling us to I guess, work through some of the really tricky issues that OPCAT raises. There are a few documents that I've alluded to there. So there are 2 consultation papers that we put out, and we put out an interim report. We put out the interim report actually before ratification, so within 6 months of the announcement of that piece of work. So, but back in September 2017. But the final paper has been a longer gestation period, if I can call it that. We've consulted right around the country, and as Stephen mentioned, we've received well over 100 submissions from experts and people with lived experience, but one way or another, people with very important information to share with us, and we've relied very heavily on what we've heard. I don't want to dwell too much on this, but there were a few big picture themes that we tried to honour because they came out so strongly about OPCAT, and we also tried to provide some useful information to set reasonable expectations. The question did come up, even though the government had finally made the decision to ratify OPCAT, it did come up a number of times. Why are we doing this again? Not so much among civil society representatives. They were saying, let me tell you again why we need to do this right now. But among some other stakeholders, government and other stakeholders, it did come up. But I want to make really clear, no one made a cogent argument against ratifying and implementing OPCAT. There was not a single stakeholder that did that. Again and again, what we heard was from people at kind of almost every end of the ideological spectrum and political spectrum for that matter, who said, of course, we are a country that takes human rights seriously. We need to be rigorous and effective in the process of inspecting places of detention and making sure that we are able to identify problems before they metastasize, before they become truly awful human rights abuses. And if OPCAT is a means for us to do that more effectively, then absolutely we should do just that. And so while not formally part of the terms of reference of our work in this space, I think it was really important for us to hear that over and over again. and for us then to be able to reflect that faithfully to the Australian government and to the state and territory governments who've also been interested in this work. So I'm hopeful that important message has been heard loud and clear. Another important sort of big picture theme has been to kind of make sure that people understand what OPCAT can and can't do. One of the things that it can do is that it can improve the way in which inspections of places of detention take place. That's really kind of the whole reason for being for OPCAT. What it can't do, at least can't do directly, is get people who perhaps shouldn't be going into detention, to divert people out of, say, immigration detention or the criminal justice forms of detention. It may indirectly contribute to that, but on the whole, what OPCAT is really all about is making sure that people's human rights are protected once they're in detention. And in that sense, it is not a revolutionary treaty. It is one that we should find very easy to grasp as a minimum standard, because it doesn't call into question some very fundamental questions that I would like to be asking separately about how many people we detained and in what circumstances. All it does is it says that if you are going to detain someone, you must adhere to those obligations that we in Australia and other countries have already acceded to, and you must have a rigorous way of holding yourself to account as a country for just that. And then another kind of thing that is not unique to Australia, but is certainly an issue in Australia, is of course we're a federation, and while it's our federal or national government that goes around merrily signing up to treaties and ratifying them, there is a division of responsibilities in our federation, and sometimes that's more or less complicated. In the detention area, it is particularly complicated because aside from immigration detention, which is a very, very important and worrisome area of detention, almost all other forms of detention are the responsibility of the state and territory governments. So it's the federal government that signs and ratifies the treaty, but ultimately it's the state and territory governments that are primarily responsible for the vast majority of people in detention in Australia. And so there needs to be really constructive processes of getting our federal system to work effectively so that we are all pulling in the same direction. That's something that I guess is an ongoing challenge, because with really only Western Australia is the only jurisdiction apart from the Commonwealth that has really kind of grasped more fully the obligations of establishing an NPM. There's a lot of work that still needs to happen at the state and territory level, and I think one of the big challenges that the federal government has is to bind all of the Australian polity together. So those are some of the big picture themes. The last thing I'm going to do just before we kind of run through to some discussion and questions, I'm slightly hesitant to call this question and answer because I don't think I will have all of the answers. I'm happy to be asked any question, but I really hope that this is a much more non-hierarchical discussion. So as I said, what I wanted to do was kind of run you through some of the key recommendations. I won't go through again chapter and verse. I'll just what I've tried to do here is group some of them together thematically. The first observation I've made here is that OPCAT is self-avowedly a human rights treaty. It is fundamentally about making sure that the practical work of upholding human rights is achieved. That's quite different from some other treaties. It's not a it's not a treaty that is mechanical, or that doesn't have that kind of normative thrust. Human rights is something that I think we can all grasp intuitively, but we can't just rely on intuition. There is now over since the modern incarnation of the human rights system just after the Second World War, there's now over 70 years of learning, of law, of jurisprudence, of understanding about what that means. And so for the different bodies, most obviously the NPM bodies in Australia that are going to be responsible for conducting visits. In Australia, we tend to use the word inspections, but the treaty uses the word visits. There's a critical role in better understanding those core human rights principles that are in CAT itself, as well as in the optional protocol. And that's something that really needs to happen up front. And so it's been very deliberate that I've put that in the first bullet point here, and then the references to education and training were in the first two recommendations of our final paper. It's critically important. Probably the biggest number of recommendations in our paper related to how the bodies performing that National Preventive Mechanism at the federal, state and territory levels would go about their role. And so we've set out in some detail some of the critical issues that need to be addressed. So what are the characteristics of an NPM that can fulfill OPCAT obligations? What are the sorts of resources that they need? What are the functions that they need to be endowed with? And how do they need to be endowed? So particularly focusing on things like independence and so on. Because again, fundamentally, the idea of conducting a visit of a place of detention, we can all grasp that, just using our common sense. But I think the real value of OPCAT is that it says, well, there are good ways of doing this that have been proven to be very effective over time. And what OPCAT does at the level of high principle is that it sets out some of those core features that an inspection body should be endowed with. And what we've tried to do, particularly with those recommendations 3, 5, 6, 8 and 11, is we've tried to flesh those out a bit more and to say, okay, well, this is the kind of checklist that the federal, state and territory governments should be looking to when they're assigning bodies with those NPM functions. The next theme is really important as well. What I've said in pretty much every speech I've ever given on OPCAT is that it's an unusual treaty in the sense, it's an unusual human rights treaty in the sense that it is not setting out new normative obligations. It's not saying there are no more, so there are no additional thou shalt not do this or that. All of those normative obligations are already set out primarily in the Convention Against Torture itself, but also in some other international human rights treaties and other international human rights law. So that substance as a question of international law was already in existence before OPCAT. What OPCAT is there for is to provide a process to make sure that those rights are upheld. And so OPCAT is fundamentally, as we know, about inspections, but you need to create some kind of bridge between good process and good substantive change. To state the obvious, it would be a terrible, terrible irony if, as a result of ratifying and incorporating OPCAT into Australian law, if we just got really, really good at inspecting places of detention, but there was no substantive change on the ground if conditions of detention didn't improve. The whole kind of intellectual foundation for OPCAT and how it is established is that if you have better modes of inspection and of course reporting, that can be a lever for change, that can lead to much better ways in which human rights are upheld for people in detention. And so through things like I've just alluded to, like better processes of reporting, of monitoring the way in which governments implement recommendations for change in detention, those are the sorts of things that we think can be really critical in moving from something that is focused on process to what we all actually care about, which is substantive human rights experience. And we, the sub point there is we've set out two suggestions that we think might be companion pieces to the ratification of OPCAT that we hope would take that forward. And there are two sets of national principles. One set of national principles regarding how inspections of places of detention should take place. And really we're talking about there a distillation of the kind of good practices and indeed obligations of how you conduct good inspections. And secondly, the second set of national principles would be national principles dealing with human rights conditions in detention. And again, what we're talking about there is a distillation of a set of disparate requirements that exist at the international level, as well as at the domestic Australian level. And again, something that can be a really useful lodestar in keeping us focused, not just on the kind of process, making sure that we're ticking all the boxes and doing what we're what OPCAT requires us to do, but that we're moving from a focus on process to actual substantive human rights protection. The next theme is kind of acknowledgement of the fact that in Australia we found this process. So this kind of OPCAT, like do we ratify? Do we sign? Then do we ratify? Then do we actually implement? We found that really difficult. And part of the reason, as I say, is I think that we're in a federation where it's the federal government that is responsible for signing and ratifying treaties, but it's the states and territories that have primary responsibility for the vast majority of people in detention. But it's not the only difficult area, and this is an area that goes to the real heart of human rights, and human rights are some of the most vulnerable people. So again, we've put a couple of recommendations in our final paper that are designed really to unblock the process a bit. I don't want to be overly critical because I recognise that this is a difficult process to implement a treaty like this, but we do need to take this forward as speedily as possible. I'm almost there, so just two more themes to go. We say a bit about the legal framework. Probably one of the more controversial issues that has come up in the last few years regarding OPCAT in Australia is the definition of what constitutes a place of detention. So there's a large number of categories of detention about which there is no controversy at all. No one's doubting that prisons and juvenile detention centres and immigration detention facilities are all places of detention. Of course they are. But there have been a few categories of detention. Oh, sorry. Well, I'm showing my colours here. I would say categories of detention where there's a question mark about whether the federal or state territory governments accept that they are places of detention. Probably the most obvious of those is aged care facilities. And again, I think it's really clear on the face of the treaty itself and the way it has been implemented in comparable jurisdictions to Australia that anyone who is deprived of their liberty in, say, an aged care facility falls within the ambit of the protective umbrella of the treaty itself, that there is no doubt in my mind at all about that. But I also accept that that can be something that can be challenging for people, at least at a gut level. At a gut level, we don't think of aged care facilities as places where people are detained in the same way that a prison is a place where someone is detained. So we need to challenge ourselves a bit more on that. I think Stephen mentioned publicly recently that, you know, we've got 2 royal commissions at the moment, one on aged care, one on disability, and I think there's been a real growing understanding in Australia that those are places, or scenarios or groups of people who have been particularly at risk of some terrible human rights abuses. And again, I feel like we have to go beyond that recognition. That recognition is a really important first step, that older people or people with disability might be especially vulnerable, but we can't stop with that recognition. We have to go to the next step, which means, okay, well, what are we going to do in order to make sure that those people are safe? And so, to my mind, I think what that means is we need to be really straightforward in applying the terms of OPCAT itself, which clearly are broad in understanding what constitutes a place of detention. And I don't think we should be trying to cavil with that. I don't think we should be trying to play any games that try and kind of exclude those sorts of places, because we know that while the vast majority of aged care facilities, no doubt, are very safe, and the vast majority of people in aged care facilities are not detained, there are some people who may have dementia and other conditions that may end up in a situation where they are deprived of their liberty, and that may be sad, but not the wrong thing. But if they are in that situation, then it is important that there are proper checks and balances so that we don't have another Royal Commission on Aged Care in 15, 20 years' time, and we're kind of asking, where did we go wrong? This is a practical way to make sure that we safeguard those human rights for the future. Then legislation, that was another, in a sense, slightly surprising area of potential controversy. Again, the treaty seems pretty clear on this, that you should have legislation that essentially safeguards the basic provisions of the treaty itself, and that's a protection primarily for NPMs to perform their functions in accordance with the treaty, and it could also be an important protection and kind of statement to the world about the role of the United Nations Subcommittee for the Prevention of Torture. I note that Sir Malcolm Evans, the chair of that committee, is on this call. And I would imagine, but Sir Malcolm is much better placed than me to make an observation about this, but I would imagine for the SPT, it is something that would give one confidence in a country taking their obligations under CAT and OPCAT seriously, if there is legislation that basically incorporates the key provisions of the treaty itself. Last, but certainly not least, is the role of civil society. So, in a sense, this last point takes me right back to the start. If I can say, please don't quote me on this. It's no great secret, but I don't want it to kind of come out the wrong way. One of the first things that I saw as a potential opportunity when I started as Human Rights Commissioner back in the second half of 2016 was the possibility that the then Attorney General George Brandis and the Foreign Minister in a supportive role could see the value in us ratifying OPCAT. And we spent an enormous amount of time, particularly myself and Mr. Brandis, going through what are the pros and cons. I must admit, I was more on the side of providing pros. I don't think I could find a lot of cons, but it was important to kind of run through all of the all of the pros and cons. But one of the things that I think he and a number of people that were close to him grasped about this was that it presents an opportunity to unlock some of the expertise of civil society when it comes to making sure that people's basic human rights in detention are upheld. And again, it's an opportunity. So it's an opportunity that needs to be grasped. So I'd like to again pay tribute to the Commonwealth Ombudsman and his colleagues for establishing a number of mechanisms that have the potential to kind of ensure that civil society input is garnered in the way in which OPCAT is implemented in Australia. There's an OPCAT advisory group. There will be other ways, I think, as OPCAT develops for civil society organisations to have formal and informal influence and input. And really, I guess what we're saying in this final paper is that those need to be seen as opportunities, not as threats to government, but as real opportunities to garner the really important expertise and experience that only civil society holds. Because these are places that government may be responsible for, government may run the vast majority of places of detention, but they don't necessarily see easily into those dark corners, but civil society organisations do. And so certainly when I've looked overseas at some of the jurisdictions that have implemented OPCAT more successfully, they tend to have quite an open mind to bringing civil society on board in that process. So I think I've spoken for a little bit longer than I'd foreshadowed at the start. I will perhaps hand back now to Stephen to kind of resume responsibility for kind of, you know, keeping, what was it called, herding cats, making sure that we're all doing what we're meant to be doing.
Thanks very much, Ed, for the presentation. I personally found that really enlightening. Covered a lot of issues that we all need to discuss going on. I'd like to move on to the question and answer session now. And as Ed noted, we'd like this to be more of a discussion. So other people are more than welcome to jump in and provide responses. I note, of course, that we have a lot of international expertise on this matter within the webinar. So Professor Malcolm Evans, the chair of the SPT, is with us. Also noticed we have Elena Steinhardt, part of the UN Working Group on Arbitrary Detention. And I did see the Honourable Lowell Goddard, who is a former member of the SPT as well. So if at any stage you want to add comments, please feel free to. I will start with the email questions I have. Just give me one moment to bring that up. The first question came from Andrea. Actually, Andrea, would you like to ask the question? Would you prefer that, or do you want me to just read it? You'd like to ask the question? Great.
Sure. Can you hear me?
Yeah.
Okay. So first of all, thank you to the Australian Human Rights Commission for the amazing work you've done in this space. I know we're all really grateful to you from civil society's perspective. So my question is, the NPM's preventive mandate requires them to look at the root causes of torture and ill treatment of detained people, including Aboriginal and Torres Strait Islander people. Your report noted that in Australia, many Black Lives Matter protesters have focused especially on the extraordinary levels of incarceration and harm experienced in detention by Aboriginal and Torres Strait Islander people. The report also stated that Aboriginal and Torres Strait Islander people are affected by conditions of detention in distinct ways due to numerous factors, including ongoing social and historical marginalisation and disadvantage, over-policing, an experience of police bias, and intergenerational trauma. In recognition of the systemic and institutional racism in the criminal legal system, should NPMs consider how systemic racism shapes the culture of a place of detention? And can it be understood as when looking at how it could be understood as a root cause of the ill treatment of detained Indigenous people?
Thank you very much for that question, Andrea. And it's a great question, and there's a lot of nuance and subtlety in there, which means that I'm going to try and give a quick answer, but it's going to be hard. I think if I can start a little bit obliquely, broadly speaking, I've seen two currents sort of pushing against each other in governments throughout Australia when it comes to implementing OPCAT. The first current is essentially parts of government who feel like they've been dragged kicking and screaming into doing this, who feel that there are already a million processes of monitoring and oversight, that they're trying their best, and that it's a bloody difficult job to be responsible for a place of detention. The second current is one that probably acknowledges the vast bulk of that, but that says, nevertheless, we've got a really heavy responsibility to make sure that people's human rights have been detained. Human rights in detention have been protected, and that too often we haven't achieved that. When it comes to Aboriginal and Torres Strait Islander people, I mean, I don't think there would be anyone on this call who would be unaware of the just shocking statistics, and you know, it goes right from the youngest, you know, juvenile detention. I can see my colleague Sally from the Northern Territory on this call. We know in the Northern Territory that you know, much of the time, young people in detention, in juvenile detention, it's anywhere between sort of 90 and 100% of those people are Aboriginal or Torres Strait Islander, and much of the time it's right up at 100%. There are so many causes of that include or are linked to racism and the historical kind of echoes of racist practices and laws. And so, yes, the short answer is yes, we do need to be cognizant of that. We need to, I guess, I think, make sure that second current in government wins out, that they see this as a way of kind of climbing a very big mountain, because it is a really big mountain. But there's no point in just looking at the mountain and just observing every day how big it is. We need to do more than that. We need to actually take the steps to start climbing it. And I think what OPCAT does is that it allows us to have another practical mechanism to do that. And so when it comes to how NPM bodies fulfill those functions, when you go into a place of detention, I think you need to do so cognizant of exactly the sort of historical and contemporary problems that I think Andrea very eloquently described. And I think what that allows you to do is looking in the right places for the right things, so that we can you know, be as effective as possible at actually fixing some of these problems. It's not easy, but I think it's vitally important.
Thanks, Ed. Thanks, Andrea, for that question. Our next question, Ed, you touched on this a little bit in the presentation, but it comes from Claire Loughnan. Claire, did you want to ask the question?
Thanks, Stephen, and thanks, everyone. I hope there's not any dog background noise happening here. But just a couple of questions, Ed. One in relation to age and disability care. What sort of avenues do you think might be available for extending the scope of OPCAT to those sites? And secondly, on a different, looking at a different site, but given the sorts of information we're getting out now about the kind of the infection risk in immigration detention due to COVID, one of the things that colleagues and I have been trying to argue is that this needs to be addressed as a health concern, a health rights perspective. What sort of possibilities might you see existing for advocating for change in terms of the treatment and even the confinement of those in immigration detention, even though OPCAT might not address the question of confinement itself, but to circumvent claims that this is just a federal border protection issue? Maybe that's a bit of a tricky question, but I'd be interested to hear what you had to say. Thanks. And thanks, Stephen, and thanks, Ed, for organising this.
Thanks, Claire. They're both really good questions. In one sense, the first question should be an easy one, right? It's not a question of extending OPCAT to apply to aged care facilities or places where people with disability are detained. If they are detained, then OPCAT applies. There's no question about it. The treaty is actually pretty clear. I'm happy to be told that I'm being overly simplistic. We've got some of the world's leading experts on this on the call. Ben Buckland from APF I can see, as well as, of course, Sir Malcolm Evans and Lau and others. But to my mind, and the position that the Australian Human Rights Commission has taken is that it's clear. If someone is deprived of their liberty, then OPCAT applies to that individual. And we know that people are deprived of their liberty in various aged care and disability residential settings. And so I don't think we should be cavilling with that or trying to find loopholes to avoid that light being shone. The second question, I think, was more about COVID-19, immigration detention, perhaps some other forms of detention. And we've had a bit to say about this over the last few months. We've spoken publicly. We've worked really closely with the Australasian Society for Infectious Diseases. We've sought their advice. They are the people that are kind of providing the core public health advice to the federal, state and territory governments on COVID-19. And they were, I think, crystal clear in the advice that they gave in respect of immigration detention. And that is that, if you are in a place where you can't practice social distancing because there are too many other people around and you're being held in, or you sleep in a shared room that is quite small with, say, a bunk bed or two beds very close together, and a shared toilet arrangement, as is commonly the case, then the risk that if COVID-19 gets into that facility, that it will spread is dangerously high. And the government, it's within the government's capacity to actually reduce that risk. We have been really clear with the government that we think the government should reduce that risk in the most obvious way, which is to reduce the numbers of people in places of immigration detention. Again, I'd draw positive attention to the work that Min and her colleagues at the Commonwealth Ombudsman's office have done. They've done an extraordinary job to do an inspection under adjusted parameters of places of immigration detention. They put out a statement just a couple of weeks ago. I think it was the third recommendation, drew attention to the high numbers of people in immigration detention facilities. The numbers are now higher than they were in March at the outbreak of the pandemic. And kind of drawing attention to the fact that the Minister has power to reduce those numbers by putting people in, say, community detention, so outside of formal immigration detention facility, outside the kind of, the four walls of a detention facility, but nevertheless with kind of oversight of them. So we are saying that that's exactly what should happen. I think that the link with OPCAT is actually kind of exemplified by the work that the Commonwealth Ombudsman's office undertook. So they are the NPM body. They undertook an inspection. They put out a really clear public statement at the end of that process. And I think it's then a question for government to respond, I think, positively to those very sensible recommendations.
I'll just, if I can just, I don't want to take any more time, just quickly, I didn't mean that extending the scope of OPCAT to aged care, but really that government recognises that, but we know the challenges associated with that. It's more about how do we get government to recognise that. Thanks.
Gotcha. Yeah.
Thanks for that. Our next question, I see Malcolm has gone to answer it, but it's from Andrew Perry. So I know the report talked about aged care being an area of controversy, and the other area of controversy was offshore processing. So Andrew, would you like to ask that question?
Thanks, Stephen, and thank you, Ed. Now, I must admit I haven't read the report yet, having just got back from some wonderful leave. Obviously didn't travel far for it, but it was otherwise good. Yeah, what I'm wondering, I can see myriad interests and actions that can be used to obstruct OPCAT even in ideal circumstances. But I'm just wondering what you see can or should be done with OPCAT to navigate and hold to account detention practices that involve multiple sovereign jurisdictions. And you know, the obvious example is Australia's offshore detention centres. And just wondering if there are any comparable international examples that we can use to, you know, I guess progress our thinking and learn from.
Yeah, thanks, Andrew. So 3 observations. The first is there's a fantastic answer in the chat towards the bottom from Sir Malcolm Evans. I'll draw everyone's attention to that because it gives a good response to the question about, I guess, analogies from other jurisdictions. 2 other observations. One, I've got one observation as a lawyer and one observation as a human, because I was a human before I was a lawyer. So as a lawyer, you know, you can have 2 jurisdictions with OPCAT obligations. So Nauru and Australia have each signed and ratified OPCAT. We each have responsibilities under OPCAT. And there are some pretty well-developed principles for making sure that an individual who may be detained in one jurisdiction, but you know, at the behest of or in connection with decisions by another jurisdiction, that each of those countries retains oversight for and responsibility for those individuals. We've seen this play out in a number of ways. To give another example in a very, very different context, you know, when Australia was heavily involved in the conflict in Iraq and Afghanistan in the 2000s, the first decade of the 2000s, you know, Australia generally didn't have much in the way of detention facilities for people, enemy combatants that were detained or I guess, stopped on the battlefield. They would hand those people over to the United Kingdom or the United States. But Australia under international law clearly retained responsibility for the human rights protections of those people. So that's your legal answer. But in a practical sense, I guess I feel more pragmatic about it. It doesn't matter to me too much whether oversight of people, asylum seekers and refugees on Nauru and Papua New Guinea for that matter, is undertaken through the aegis of OPCAT or some other kind of equivalent way of making sure that those people are properly cared for and overseen. All I care about is that they are properly cared for and overseen, and that I think is fundamentally what we should be pushing towards. So if the Australian government wants to kind of run an argument, essentially that for some technical reason our obligations under OPCAT don't extend to Nauru, even if one were to accept that argument, nevertheless, we still have international human rights law obligations to maintain the human rights protections of people in those 2 places, in Papua New Guinea and Nauru. And so one way or another, they've got to make sure that that is actually being achieved, whether or not it's through the mechanism of OPCAT.
Thanks, Ed. So Malcolm, did you want to make a comment on the jurisdictional issues that have been brought up about aged care and offshore processing? Just from your view.
Sure. Thank you. Just to be, you know, brief on the aged care issue. I'm conscious that this is one that has attracted a huge amount of attention over the years, and indeed I'm not entirely sure why, because I think from our perspective the matter's always been fairly straightforward. You know, the OPCAT mandate runs to any place where a person is deprived of their liberty, interpreted in the sense of not being free to leave, and that can actually be anywhere. You know, for the moment, you know, we are wrestling with, or rather not wrestling with, the application of these same principles, for example, to places of quarantine detention and things of this nature. It's a functional approach rather than an approach based on the nature of a facility or a sector. People can be detained just about anywhere on that basis. And so I've always tried, and the SPT has always tried, to resist the, if you like, production of lists of places which are or are not within the list of the mandate. You look to the question of whether a person de facto is or is not free to leave, and that can equally be within an aged care home as it could be within a children's home, within a prison, a police station, a psychiatric hospital, or just about anywhere else you choose to think of. Obviously, for the OPCAT definition, there must also be an element of linkage to public authority, which distinguishes it from other situations where a person might not be free to leave, and that is catered for in the views that we've put forward to situations where there is government regulation, i.e. where a place could not be able to function as most aged care homes can't, but for inspectoral regimes that give it a license to operate. So if you have a place which operates under government license, and within that place a person de facto finds themselves unable to leave due to the actions of those charged with running the place, for our purposes it's a place of detention, it's in the OPCAT mandate. So that may sound it may make it sound longer and more complex than it really is, but I don't think that it that it is, and the sooner that one can be nailed, and I know you've been doing a fantastic job of trying to bring this home, the better. And I might add, there are endless other types of, shall we say, unusual, I will only use that word, detention facilities that one finds in very many countries where similar issues arise. Just to name a couple of controversial ones, in some countries you have what are known as prayer camps. You may get some forms of educational institutions which de facto are operating in the same way, and they can fall within the scope of the terminology too. As regards the extraterritorial element, I think much as all it's really in the same way already been covered. Again, no real magic to it, but if you are procuring, let us say, the de facto detention of a person in a third state, it is, as I put in the note, incumbent on you, shall we say, to ensure that that detention is at least covered by OPCAT compliant inspectoral oversight. Where you've got two countries which are parties to the OPCAT, this is fairly straightforward. It can get a little bit more tricky from an OPCAT perspective where one of those countries was not a state party. But even then, it is possible, and you can read into this what you like, if you had a situation, for example, where someone is a signatory of the OPCAT but not necessarily a state party, a different obligation would arise as a signatory not to frustrate the object and purposes of the convention. And we have also taken the view that if you have a country which is not a state party but is a signatory to a convention, which causes another state party to be in breach of its obligation by placing persons in conditions of detention which are inhuman and degrading, then that too can amount to an obligation of your a breach of international law obligations under the Vienna Convention, which places the obligation on state parties not to breach objects and purposes, which clearly can include the facilitation of a breach in a third state. And so there are plenty of different ways around this, but where you have, as we have here, a situation of two countries which are a state party, it's fairly straightforward. Similarly, we've taken a similar view in relation to extradition flights, returns to third countries between states parties. And in a sense, there's no magic here. Again, this is simply drawing on pretty old approaches which for years the UN Committee Against Torture has applied in the context of deportations, extraditions, etc., within the context where it has always said that the risk of ill treatment or of a breach of the convention, in this case the CAT, the UNCAT, is considerably lessened, i.e. a risk is mitigated if both countries are party to the international instrument. So it's really only the application of very well long established principles in this particular context. And so, you know, it shouldn't be viewed as something, shall we say, radical and controversial.
Phew.
Very much, Malcolm, for that explanation. Although you make it sound simple, it's not, in my mind, it's not simple, but thank you anyways. I'm mindful of the time and I don't want to go too over time. So there are 2 questions left. I'd like to hand over to Val Kitchener, who has a question for Ed and Malcolm. Sorry, Val, your microphone's on mute.
Okay. I'm in a small state and our focus is on prisons and mental health facilities. We don't have other detention centres. Sorry, I should include youth justice as well. I've been the project leader to try to establish an OPCAT network in this small state, because I think in a lot of ways being small can mean that your people are even more disadvantaged, and that's true in Tasmania too, where our social determinants of health are really quite alarming. We die a couple of years earlier than people in other states. So there are a lot of issues that I think are very OPCAT relevant. I've been, as well as an academic, I've actually been an official visitor in mental health facilities for 10 years. So I know our facilities and our prisons fairly intimately. The thing that interests me though is how, and this is relevant to this small state, perhaps more than in other places, how we can engage universities and whether or not there are discussions around the role of universities and how they relate to civil society. In some of our not-for-profits, I think universities are now seen as competitors for funding rather than as organisations that traditionally have been there to serve civil society. So, Malcolm, you began to touch on some of this in a previous presentation, I think, in your comments about definitions of civil society. But I also wondered, Ed, if you, in your awareness raising, if you've thought about awareness raising in universities.
Yeah, I mean, I've, in my personal experience, have benefited from lots of input from academics and people from more traditional civil society organisations, NGOs and so on. I've been both an academic and worked for several years in a community legal centre, so a typical NGO. And I can see, you know, there's enormous value in both. I saw Bronwyn Naylor on this call, who's been one of the most stalwart kind of experts on OPCAT in Australia for many years. She and a number of other academics, Sophie Farthing from the Human Rights Commission and myself, we all kind of came together to edit a special issue of the Australian Journal for Human Rights on implementing OPCAT, and that in a sense was a kind of a good way of exemplifying how academics and others can come together and share their different types of expertise. We found the kind of output of that process incredibly useful for our own work, and I'm sure the Ombudsman and others have as well. So I think, I mean, I think it's reasonably straightforward. I think anybody who has expertise in this has a role to play, whether it's expertise in the intricacies of how OPCAT operates itself, or in the experience of people in immigration detention or other forms of detention. I think both are incredibly useful sources of expertise. And then I think, as you yourself alluding to there, Val, it's a question of kind of unlocking that expertise and making sure that those people feel engaged and valued. And I guess a couple of the recommendations in our report, in our paper, were designed to do just that, to find practical ways of unlocking that expertise and making sure that people are aware of the work.
Could I just add one very brief point to that? I agree with everything that Ed said. That the universities and the like can play a hugely important role in very many different ways. We don't want to map it all out, but the only thing I would add to that is that one of the things that we found has been very helpful in many jurisdictions is that they can provide should we say, a rather different sort of space for discussions between certainly sometimes national authorities, civil society and others that it's difficult to have in other contexts, because they can place it in, you know, what can be a challenging, but so should we say, a more, dare I say, neutral environment, and can couch things in a different way that makes it easier to have sometimes some quite difficult discussions about things that if they were taking place in other ways. So if you like, the convening power of universities is something that actually has proven very helpful in many jurisdictions to take events and, you know, and take things on, as indeed I know you know already in Australia, through the convening power that has been done through this group and others to try to push for OPCAT ratification. And, you know, other countries, you know, and to name a name, Ireland is a good example at the moment where similar things are being done. And so very valuable role to play. It's a question of finding, you know, just how to harness it. But you also, let's be honest, Val, you're quite right about the competition for funding, and the way around that is simply to get alongside each other and work out a joined up strategy about what serves the interests of everybody here, rather than just do it in isolation and just cut across each other. But it is a real problem, no point denying it, and thanks for raising it.
Thank you, Val, for the question. I'm going to ask the last question, if that's okay. Given the release of the final paper, does the Commission see it has a continuing role in the establishment of the NPM, and how does it intend to work with the Commonwealth Ombudsman and governments to monitor the implementation of its recommendations?
I mean, informally, yes, we're still here as a source of expertise and as a kind of an admiring friend of the Ombudsman and other bodies that are responsible for the core work of inspections under the OPCAT rubric. We, ever since there's been immigration detention in Australia, a very important part of the Human Rights Commission's role has been to conduct inspections of immigration detention facilities under a human rights rubric. We will continue to do that. We are continuing to do that. And so through that sort of informal process, we can continue to kind of advance some of the principles that OPCAT shares with other international human rights treaties. But formally, yeah, we acknowledge gratefully that the lead organisation is the Commonwealth Ombudsman's Office from here on out.
Thanks, Ed. Ben Buckland wanted to make a couple of points, so I think we've got time for that, another minute or so.
Thanks, Steve. I won't be very long at all. Just thanks to everyone. Thanks to Ed, and congratulations on the publication of a really fantastic report. I think it's such an important milestone in getting Australia to fully functional OPCAT system. Just very briefly, I think a couple of points were made over the last hour about what NPMs can or cannot do, and you made a point about whether NPM should be involved in diverting people from detention, and Andrea, there was a point about whether NPMs can be involved in responding to systemic racism as a root cause. And I think just very quickly, my sense is that NPMs can absolutely do all of these things, and I think if we look around the world, there are so many examples of NPMs that have really used their mandates creatively to get to the end goal that we all want to see. And the example of Paraguay comes to mind, where the NPM there was directly involved in closing a really large number of care homes for children and deinstitutionalizing the kids that were held there. And I think if we look at what NPMs have been doing during the COVID pandemic, if that's taught us anything, it's that NPMs really need to be creative in the interpretation of the mandate, the ways they monitor, the places they monitor, and the kinds of recommendations they make that get us to the solutions that we want to see. So just that very quick point. And yeah, thanks to all of you. It's so encouraging to see the just extraordinary expertise on this call, and I'm really grateful to have been able to participate. Thanks a lot.
Thanks, Ben, for your comments. So in wrapping up, I'd like to hand over to Professor Bronwyn-Naylor for some concluding comments.
Oh, well, thanks a lot, Steve. And I know that the time's running, so if people need to go, we understand that too. So thank you so much. Thanks a lot, Ed, and thank you to all the people who participated here in the call as well. The Human Rights Commission, as we know, has been involved with the implementation of OPCAT in all its stages, and in fact right back to, I think, the late 2008, just after OPCAT really opened for ratification. The Human Rights Commission has been really active and engaged, and it's been really great to catch up on this latest report. And many people, of course, on the call will have participated in the extensive consultations that have underpinned this really important work that you've been able to do at the Human Rights Commission. So this is fantastic. And I should say thank you, Ed, as well, for mentioning the special issue of the Australian Human Rights Journal. Again, there are a number of people on the call who've contributed articles to that as well. So if people would like to get that reference, I can certainly send that on to the network again. So just, I mean, very briefly, as Ed's emphasised, the whole point of OPCAT is about changing conditions in detention. It's about prevention of human rights abuses, and I guess that goes back to some of the points we've been discussing. Really helpful to get a bit of a picture about from the recommendations in this report about how we can proceed with implementing OPCAT nationally in the context of a federation. That's kind of been the challenge. So from the national perspective, great to see those recommendations around national development, national inspection guidelines, national statements about minimum conditions of detention, the importance of a statutory base, and obviously you've got to focus on the national perspective in the Australian government, but it's so important to be able to leverage this through so that the states and territories are actively engaged and are actually going to take on board what's needed to make OPCAT work. The continued importance of civil society organisations absolutely goes without saying. We're saying it now, and I've always noted the importance in these consultations that you've been running and the work that we've all been doing in advocacy, the critical role of civil society organisations. And I think today's discussion and the presentation, the questions, the really engaging questions, and fantastic responses from so many people with expertise who are on the call. So I think I'll just finish up with that, but just to say thanks so much. It's been terrific, and let's hope we can keep these kind of discussions and debates going on, because it's really important to have all this engagement to make this work the way it can be a really effective product, a really effective change in Australia. So thanks very much.
Thank you, Bronwyn. I'd like to thank Ed Santo for his time. Thank you for your expertise and of course for the report and the leadership you've shown on OPCAT ratification, both pre-ratification and post-ratification. We know that you'll continue to have a space in the OPCAT space, no doubt. And I'd like to also thank all of our special guests and contributors, those around the world, Professor Malcolm Evans, Ben Buckland, our friends in New Zealand, and all across Australia. I hope that you found this enjoyable and enlightening, and obviously we still have a far way to go with regards to the actual establishment of the NPM and some jurisdictional issues, of course. But certainly I think as a country we are well developed and well on the way to potentially being one of the best practice models for the rest of the world, and particularly for federations. So I thank you everyone for joining us. The links that have been mentioned in the discussion will be sent to you in a separate email, as well as a recording of this video. So appreciate all your time, and sorry we went a bit over time, but thanks again.
Thank you very much, Stephen, and thank you all.
Thanks, Steve. Thanks,
See
Ed.
ya.
Bye.
Thanks, Stephen. Thanks, everyone.